So Daniels' plea closed that case out. Whew. It was a mess. Hope it was a good music video. Deputy Gordon, can you check? Mr. Render can speak with his client as long as he wants, but we could take this plea while that's happening, unless we don't have enough deputies. We do. Great. Daniels is a plea. If Mr. Render needs more time, they should keep talking, but then I'd like to take the plea while they're having that conversation. Sorry, investigator. Just trying to keep things flowing.
Yeah, they agreed to that. And also, there was a second probation. They're gonna run it concurrently. They're on your probation case. Second probation. Yeah, you barely have two.
Ms. Dilligard, because, well, I guess it's just easier if you come up here. I say because Ms. Rivers is here, you could be there, but it's easier for Mr. Daniels if he can be looking in your direction. So we'll do that. All right, well, Ms. Dilligard is getting settled. We'll get on the record. This is 24 SC 004566, State versus Joseph Daniels. Good morning, Mr. Daniels.
Good morning, Your Honor.
You were here yesterday or the day before, and your attorney, Mr. Lim, had court obligations elsewhere, so he was here virtually. And it turns out you were ready to resolve your case. We just couldn't do the plea in that setting because whatever parking deck Mr. Lim was in had titanium shielding, and we had a bad signal for him. But he's here in person. So we've got Mr. Lim and his client, Mr. Daniels, Ms. Dilligard, here for the state, and she's going to put you under oath in just a moment and ask you a bunch of questions about your rights as a criminal defendant, things you and Mr. Lim already discussed. You need to answer her truthfully. If at any point you need to speak privately with Mr. Lim, let me know. We'll get you back there. Or if you have questions for me, you need to interrupt. Just say, wait, and either your lawyer or I will answer the question. Okay?
Okay.
All right. Ms. Dilligard, when you're ready.
Mr. Daniels, can you please raise your right hand to the best of your ability? Do you swear or affirm that any statement or testimony that you should give in the matter currently before this court shall be the truth, the whole truth, but nothing but the truth?
I do.
You can lower your hand. Please state your true and correct legal name for the record.
Joseph Daniels.
Mr. Daniels, are you at this time taking or under the influence of any medicine, drugs, or alcohol?
No, ma'am.
Is there any medication that you normally take that you did not take today?
No, ma'am.
How old are you and how far have you gone in school?
I'm 26 years old and I have my GED.
Where'd you get your GED?
At Central State Prison.
How long ago?
2018.
Okay.
Do you understand that you have been charged with the following offense? It's 1 count of possession of a machine gun.
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to that charge?
Yes, ma'am.
Do you understand that if you plead not guilty or remain silent and refuse to enter a plea, then the state is required to prove the charge against you at a jury trial?
Yes, ma'am.
Have you had enough time to speak with your lawyer about the charge in this indictment, including the facts and circumstances related to the charge?
Yes, ma'am.
Would you like any more time to discuss the case with your lawyer?
No, ma'am.
Are you satisfied with your lawyer's services?
Yes, ma'am.
Counsel, do you waive formal reading of the indictment and waive any and all defects for purposes of the plea?
Yes.
Mr. Daniels, do you remember having been arrested on this charge?
No, ma'am.
Well, you recall what this situation involves. At some point, there was this music video being filmed, people were driving in a Mercedes, et cetera, and people got arrested. Do you not remember being arrested? Not the specific day, but in general, being arrested in connection with this?
I remember the case, but I haven't been charged with this before.
Okay, well, I'll let Ms. Dilligard explain. It may be that you got arrested for something else and these charges caught up with you. But I'll let you keep going. I don't know the specific facts of who got arrested when.
Okay, so the day of the incident, were you taken into custody?
Yes.
Okay, that's the arrest we're talking about.
Yes.
Okay. Has your attorney advised you of the minimum maximum sentence for this charge? This charge carries a sentence of 5 years.
Yes, ma'am.
Do you understand that today you are entering a negotiated plea of guilty, which means that the state will recommend the following sentence to the court? Judge, the recommendation is 5 to serve 9 months, community time served. No contact with his co-defendants. There's a stay away from the Whitehall, 355 Whitehall Street Southwest. And Mr. Lim, what was the amount of community service you have on there?
50 hours.
50 hours of community service. Judge.
All right, that's consistent with the other sentences you've been asking for?
Is that your understanding of the recommendation, Mr. Daniels?
I think the month is a little less now because we originally started with 9 months, but the idea was to do credit for time served.
Yeah, I commuted it to time served.
Her request was to, she could ask for 1 million months. It was to reduce the time served. So whatever time Mr. Daniels has served would be what he serves. I'll look at that and make my own decision. But I heard the same, 9 months, but I also heard reduced to time served. So if, I don't know the math, I'm actually going to check in a minute. If you've done 8 months, that doesn't mean you're going to serve another month. The state's request was basically reduced to time served.
Yes, Your Honor.
So that's your understanding of the negotiated?
Yes, ma'am.
Do you understand that the court is not required to accept the state's recommended sentence?
Yes, ma'am.
Do you understand that the court has the right to sentence you to the maximum possible sentence on this charge?
Yes, ma'am.
Do you understand that the court decides to order a sentence that differs from the plea you were expecting, that you have the right to withdraw your plea of guilty?
Yes, ma'am.
Are you currently on probation or parole anywhere?
I'm on probation.
Do you understand that if you're currently on probation or parole, your probation or parole may be revoked based on your entering of a guilty plea today?
Yes, ma'am.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit?
Yes, ma'am.
Do you understand that if you're on probation, you must follow all the special conditions of your probation?
Yes, ma'am.
Do you understand that if you fail to follow the special conditions of your probation, then you'll be subject to revocation of that probation for the balance of your sentence?
Yes, ma'am.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes, ma'am.
Are you a United States citizen?
Yes, ma'am.
Do you understand that by entering a plea of guilty today, you're waiving any and all defenses, including any mental health defenses?
Yes, ma'am.
Do you understand that by pleading guilty, you are giving up the following rights: the right to a trial by jury, the right to remain silent, the right to confront witnesses against you, the right to the assistance of counsel, the right to the presumption of innocence, and the right to appeal if convicted of these charges at a trial?
Yes, ma'am.
Is it your decision to waive these rights and enter a guilty plea today?
Yes, ma'am.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No, ma'am.
Is it your decision to enter a guilty plea because you are in fact guilty?
Yes, ma'am.
Mr. Daniels, how do you plead to the charge of possession of a machine gun in indictment number 24 SC 004566?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
Do you understand that you only have a limited right to appeal this guilty plea conviction?
Yes, ma'am.
Do you understand that if you wish to challenge the voluntariness of your guilty plea, you must do so by filing a habeas corpus petition?
Yes, ma'am.
And do you understand that for a felony charge, you only have 4 years from today to file that petition?
Yes, ma'am.
Judge, if this case were to proceed to trial, the state contends that the evidence would show on August 7th, 2024, officers responded to an armed call at 355 Whitehall Street. When he arrived, he was made aware that there were multiple males armed with masks, supposedly shooting a music video. Officers tried to detain the individuals to run checks on all of the firearms. They instead got into a Mercedes-Benz and fled. The car was stopped. A traffic stop was initiated because the windows were heavily tinted. The officers asked all the windows to be brought down. Officers then saw in plain view a drum magazine in the back seat. All the men were detained, and a total of 6 firearms were recovered from the vehicle. Mr. Daniels had a Glock 26 on his person, and then he also had the firearm with the switch on it at his feet. All of this occurred in Fulton County, Georgia, Judge.
Mr. Daniels had a gun on him, not the fully automatic one.
No, he had one on his person, and then
Yep.
he had the fully automatic by his feet.
Got it. Okay. And this was the vehicle Mr. White was driving.
Yes.
Okay. Got that. Okay. Thank you. Good morning, Ms. Jackson.
Good morning, Your Honor.
Can you please share any criminal history information you have on Mr. Daniels?
Yes, Your Honor, he has 9 cycles. The last arrest was March the 23rd, 2021, with the City of Atlanta Police Department for possession of marijuana with the intent to distribute and possession and use of drug-related objects. That charge was null pros on April the 21st, 2022. He does appear to be on first offender probation, but that's a juvenile case, Your Honor. Would you like that case number and information?
When you say it's a juvenile case, he was a juvenile, but it's an SC number or it's a juvenile court case number?
It's an SC number, Your Honor.
I would like that number, please.
14 SC 127863. That disposition date was June the 9th, 2015. And the term is for 14 years of probation for robbery.
All right. Thank you so much.
All right.
Is there a warrant? I saw in the system what looks like an active probation warrant for Mr. Daniels.
Of revocation.
We wrap everything up together. Okay. All right. We'll cover all that. Was that your understanding, Mr. Lim? We can waive, if you're willing, Mr. Daniels' due process notice rights, because I don't think it was on the calendar to handle the revocation. Not my case. I'm going to look it up in a second, but it was transferred to me. That's super. Okay. Then it is my case. I was going to handle it anyway, but let me pull that up. Okay. Hopefully that prints out. It's not supposed to be transferred, but I'll work through that. They're supposed to keep the case, but the revocation is handled elsewhere. That's a Judge McAfee issue that I will fix. It doesn't affect what we're doing today. Mr. Lim, what do you want to tell me about Mr. Daniels?
Your Honor, the facts is pretty much as that. I just wanted to make sure that I bring out to Your Honor's attention that Mr. White did agree to be responsible for that machine gun. However, with him having another gun on his person, it could be really worse for him. So he agreed to go ahead and take care of this today.
And I'll note that while it wasn't charged, we had a situation of first offender in possession of a firearm. And I'll be thinking about that as we work through this. It's not charged, but Mr. Daniels, you should know, you do know, as long as you are under your first offender sentence, that you have for how many more years?
9 years, 5 months.
Okay, so for a minute, you're gonna be 35. Between now and then, you can't have a gun on you. That's a violation of your status as a first offender. You're not a well, you were gonna be a convicted felon after this, but you weren't before today. There's now a second reason not to have a gun because you'll be a felon through this. But for future reference, even your first offender case, while you're under sentence, prohibits you from having a gun. And forget about a fully automatic one, just that Glock was something that you shouldn't have had on you, even if it was just for making a music video. I understand what this started out as. All right, anything you want to add, Mr. Daniels, or you feel like you understand what we're talking about?
I feel like I understand, Your Honor.
Okay. When you get out, where do you go? Do you have a place to stay?
Yes, sir. 3071 Middleton Road.
And what's there?
My grandmother's house.
Okay. Is that where you were staying back when this happened?
Yes, sir.
Okay. Who else stays there besides your grandmother?
My grandfather.
Okay. All right. One of the conditions of your sentence that you're agreeing to is that you'll be staying away from the other defendants in this case. And I had the same conversation with Mr. White earlier this week. I don't know how you know them all, but I know that Mr. Key, I think, is the one, fancies himself as something of a musician and has a following. And that might be kind of an attractive thing to do, to be in his entourage because there's money involved or nice cars or who knows what. You can't be around him anymore because of this sentence. That might make it easier for you to stay out of trouble, but I want to make sure you understand what part of your sentence is.
Yes, sir.
You can hang out with other people, but not any of the guys who were your co-defendants in this case.
Yes, sir.
Okay. Any questions about anything else?
No, sir.
All right. So what I'm going to do, Mr. Daniels, is mostly follow the recommendation. I find there's a factual basis for your plea. I also find that your plea is knowing and voluntary. Knowing means you've understood what we've been talking about. Voluntary means no one's forcing you to enter this plea. You agree with that?
Yes, sir.
Okay. I'm sentencing you under the Probation Options Management Act. And all that means is that while you're on probation, if you have a small issue, this would not be a small issue, but maybe you miss a meeting with a probation officer, that you will sort that out with probation. You don't have to come to court. But if it's more significant, you get arrested for anything, that comes back to me. So for the only count, I am sentencing you to 5 years to serve 6 months with the balance probated. You'll get credit for time served. My math is that you've done 166 days. You are 14 days or 2 weeks shy of getting to the 6 months. You'll get credit, like I said, for all those days, and the sheriff might well let you out a little before the 6 months. But I'm tacking on a little bit. To me, 6 months is a more significant marker of the fact that you were on first offender probation when this happened. And you're kind of going to get a 2-for-1 here because I will revoke your probation, but I'm going to revoke it for the same 6 months. The balance of your sentence is probated. Condition number 1, special condition. These are all ones where if you violate a special condition, it means you actually could have all your probation revoked. Number 1, no contact with any of your co-defendants. Number 2, stay away from that address at 355 Whitehall. 3, 50 hours community service. And then 4, and you all hadn't talked about it, I'm adding this on here, you're forfeiting whatever was seized. So it sounds like the police seized a gun. You can't go now down to APD or wherever it was seized and say, my case is resolved, give me that gun back. You can't have a gun anyway, so it's a pretty easy forfeiture. But you shouldn't try to reclaim any of your property that was seized as a result of your arrest in this case. Mr. Lim, do you waive Mr. Daniels's due process notice rights in connection with the revocation in 14 SC 127863?
Yes, Your Honor.
All right. And all that means, Mr. Daniels, is we can take care of your revocation as well. So you don't have to come back and see me. Really, you should go see Judge McAfee, but he messed that up. I'm going to revoke 6 months of your probation in that other case, and then reinstate the balance. I will not revoke your first offender status. You should know, for future reference, if you catch a new case, not only will you have new charges, but Judge McAfee, to whom this 14 SC case will be returned, has the ability to resentence you in that case because you're a first offender and there's 20 years to work with that robbery. And so I'm making this up and I hope it doesn't happen. But if a year from now you get arrested with a gun and maybe you took something that belonged to someone else, you're going to have that new mess. You come to me because you'll have some probation left on this case. All I could do is revoke some probation. You go to Judge McAfee and he could say, you're not a first offender anymore. I'm resentencing you. I'm going to sentence you to 15 years because that robbery is a 20-year window. I don't say that to spook you, just to let you know this is the reality of what's going on. You are growing up. You are hopefully in a position to make better decisions, but you also, it sounds like you've been in and out. If you were in Central State, was that in connection with the robbery case? Why were you in the Department of Corrections?
It was for the robbery case. I had caught when I was a juvenile, and they sent me to Iberis.
So you did some time in custody and then had a bunch of probation.
Yes.
Got it. Okay. Well, so you've been down there before. No need for you to go back. Do you have any questions or concerns about anything I've described?
Will the 166 days be credited in the revocation?
Yes, sir. You get credit for time served there as well.
Okay.
So you got 2 weeks left, max.
Okay.
Again, the sheriff may say 2 weeks left, let's just move this along. I don't make that decision, but the two sentences are the revocation and the custodial part of this sentence, the 6 months, they're running together.
Okay.
All right, Mr. Lim, anything else?
No, Your Honor.
Thank you for coming down here, Ms. Dilligard.
Nothing further, Judge.
All right, that's it.
Thank you.
Whoop, hold on.
I just want to make an announcement. So, he is still on probation for, the possession of marijuana charge that he got in 2021. That case expires less than a month, so we're not touching that case.
Oh, okay, I didn't know that was another case. Ms. Jackson had said it was null prost. I guess some part of it survived.
I guess so. We're showing that it's in active status, but it expires literally in like 2 weeks.
Okay, that's sort of when he's getting out anyway. So that case will be closed out. You'll be on probation in 2 cases.
Okay.
All right. Oh, right. Thank you. Mr. Lim, is it all right if someone in my office electronically signs your name to the indictment?
Yes, Your Honor.
And Ms. Dilligard?
Yes, Judge.
Mr. Daniels, can we electronically sign your name indicating your plea to this gun case?
Yes, sir.
All right. That's it?
May I be excused, Your Honor?
Yes, sir. Appreciate you coming down. All right, Deputy Gordon, it is time. Mr. Arnold needs to come out here and do what he's going to do. We got an officer here and we can go forward or he cannot go forward. We need to do something. So Mr. Arnold needs to come on out.
Sorry, Your Honor, there was a new offer placed on the record.
Okay.
And I believe we're going to accept the new offer.
Okay. Knowing that that's simply what the state's going to recommend, not necessarily what I'm doing. Okay, great. Let's see what happens.
Can Judge, the officer need to take credit?
He shouldn't leave yet, just in case no, you don't need to testify yet. Yeah, got it. Let's get on the record first. This is State versus Arnold. Mr. Arnold has 2 cases, 22 SC 180449 and 17 SC 153471. Mr. Arnold is here with his lawyer, Mr. Render, and Ms. Dilligard represents the state. Mr. Arnold, we are together because I've signed 2 probation warrants, one in each of your 2 cases, alleging that the warrants allege that in January of this year, just about 3 months ago, you committed an aggravated assault and a battery. That's all it says. So the allegation is new offenses. If admitted to or proven, and we have the detective here to talk about whatever that situation was, that would be a violation of your probation, and we need to sort out what the consequences of that should be. You've got a little under 2.5 years left on your older case and 3 years and 3 months left on your newer case. So it's a meaningful amount. You were in court maybe a month ago or so when Ms. Dilligard explained to Mr. Render that the state was going to be seeking a fairly substantial amount of time because new charges aren't ever a good thing, but you were on probation for 2 cases. And so you and your lawyer said, oh, I'm not interested in that offer. State, you have to prove it up. And that's why we're here, is for the state to prove it up. But Mr. Render tells me that with some back and forth between your lawyer and the state, there may be an agreed upon recommendation. I need you to understand that I will certainly listen to that recommendation, but it doesn't bind me. And if I do something different, you don't get to say, wait, no, now I want my hearing. You understand that? Yes?
Yes, sir.
Okay, great. Then why don't you tell me, Mr. Render, what you think we ought to do, given that I assume, I don't know if there's an indictment yet in this case, but there's an open case. So it would be that Mr. Arnold is stipulating to the fact that he was arrested for those charges.
For the specific purpose of this hearing,
Correct. Okay. Tell me what you think ought to happen.
Your Honor, you want to stipulate to a new criminal law violation, and we'll come to an agreement with the state for a 12-month revocation.
Okay. And reinstating the balance in the cases?
That's correct, Judge.
All right. Let me see.
Judge, I believe that probation is wanting to terminate the balance on the 17 and reinstate on the 22.
Which is longer anyway, and then it's just one case that we're having to follow around. Okay. Okay, I understand that. Ms. Dilligard, anything you want to add?
Nothing in addition, Judge. I do have, I was prepared to move forward. I have an officer and the victim outside, but she'd prefer to stay outside while we do this, but I just wanted to bring to the court's attention that she is here.
Okay.
And that we do agree to the 12-month revocation in this case.
Okay. And you've talked to the victim about that. Not that she has a stake in these older cases, but it might result in a certain outcome for what I'm going to call her case. She's the victim, not the defendant. But as you know well, the state might be influenced by, gosh, Mr. Arnold's doing a year, and so the way we'll resolve the new charges might be, and I'm making this up, and the new charges may not have sufficient basis to result in a plea, but 5-1, and there's the one.
Yes, Judge. The victim was very traumatized and very nervous about coming in here today. So to be able to resolve it short of having to go up there is what she's comfortable with.
Okay. And since I would have learned a little bit about this, what was her connection to Mr. Arnold? Did they know each other?
Yes, Judge, they were dating at the time.
Okay. All right. But it doesn't look like she has anything to do with the older cases are drug cases. And this is a domestic situation.
Yes.
Okay. Thank you for sharing that. Ms. Simpson, anything you have to add?
Due to the nature of the crime, my initial recommendation was actually going to be to revoke 2 years. But after some back and forth with Ms. Dilligard, we're good with revoking those programs.
Okay. And to keep the alleged victim from having to come in here and talk about it. That's always something important to consider. Had Mr. Arnold had other revocations on his newer case, the 22 SC?
Not on the 22 SC, but he was previously on the 17s.
Okay, maybe because of the 22 SC. But since his plea on the 22 SC and being put on probation on that case, this is the first situation that's come up. Okay, all right. Mr. Arnold, is there anything you want to share with me or any questions you have?
No, Judge, it's just,
I would say, Your Honor, we have a different perspective on the outcome of the case, which is why we're stipulating to the specific purpose of this hearing. We do have a third-party witness who was there to see all events, and our perspective is completely different. But based upon my expertise, based upon the situation at hand, I've recommended this recommendation to my client, and he has begrudgingly accepted. But we are here.
Okay, I appreciate that. That's an important thing to add. Mr. Arnold, you're not admitting through this revocation that you did the things that might be ultimately alleged in an indictment. If the state seeks an indictment in connection with this January situation, you're admitting you got arrested for it. Getting arrested for something is a violation of probation. And there are two sides to each story. But Mr. Render has given you good advice. For this proceeding, had it gone forward, it's not reasonable doubt. It's preponderance of the evidence. And so it's basically, if I think it's more likely than not that what the young lady was saying, as maybe corroborated by what the detective said, then your probation gets revoked. Very different from a trial where a jury has to be pretty darn convinced that the state's case is the only way to explain what happened. If they're kind of struggling, well, he said, she said, and I believe her a little bit more, that's not guilty. But if you believe her a little more than him, that's revoke, because that's a preponderance on the side of, yep, it happened. So I appreciate Mr. Render's explanation for what's happening here. Mr. Arnold, I find that you violated the terms and conditions of your probation in connection with the January 2025 incident. I also find if it is as serious as the allegations are, probation's original recommendation was not a bad fit. But it is important to take into consideration ways in which to minimize the impact on victims in cases. And Ms. Dilligard, in speaking with this person, has concluded that plea bargaining a little bit makes sense. And I will follow those negotiations and revoke 12 months of your probation in both of your cases, 17 SC and 22 SC. I will close out the balance or terminate the balance of your probation in the 17 SC case. So when you're done serving the revocation period, that case is done. It just helps administratively. You will still have all the remaining time in your newer case, the 22 SC case. And that balance I am reinstating, and I am directing that it be a supervised term of probation until it expires. You'll get credit for the time you've been in. You're just shy of 3 months, but you'll get credit for all of that time. Ms. Dilligard, anything else in connection with the revocations?
Nothing further, Judge.
Mr. Render?
Nothing further. We'd just like to thank the court and thank the state for the recommendation.
Okay, thank you, everyone. And thank you, sir, for being here. Have a safe weekend.
All right. So what I'm just looking at one.